In deciding what order to make, the court looks at a variety of factors. CPR 44.4, CPR 44.2, 4 to 5 are where we find that, and includes everything from conduct to whether the whole or part of a case has been won and any offers have been made. So you look at the orders then that can be made. It's CPR 44.26, and they can be from one party to pay all the costs of another, for the other party to pay part of the costs, to neither party having to pay either costs, and there being a no order to costs on the whole matter. So the court doesn't like making an order which is different from the norm. They like their position, and that's why we have the rebuttable presumption that it stands. So if they're going to make an alternative order, it needs to be a good reason to do so. Firstly, looking at the conduct, the most common situation is where a party has acted in a way that has caused costs to considerably increase. It's not simply the defendant defending a claim. That's normal. They expect the defendants to defend. What they're looking for is a party forcing, for instance, a party forcing another to make an application which they know they would consent to and would easily be approved by the court and could be dealt with easily by a consent order rather than an expensive application. Or, which is quite often the place when they happen, is in respect of disclosure, where one party hasn't complied with disclosure, or they're forcing the other to do extensive investigations in respect of disclosure, which are above and beyond what is normal, and have then caused the other side to carry out a considerable amount of work and incur costs that otherwise wouldn't necessarily need to be incurred. So I said, it's something that's above and beyond the norm, and is then caused costs as a result of what the party has done and their conduct. It's a very subjective test, and it will depend on the case and the judge making the decision. You also need to make sure that if you're asking for an alternative order, that you've been well behaved throughout the litigation as well. There's no point asking for an order because the other side, an alternative order because the other side has poor conduct, when your conduct has been as bad as well. The courts will just say you're both as bad as each other, I'm not making an alternative order. So looking at the next factor is whether or not you've won a whole or part of the case. This is a more common order in the commercial courts. Quite often we'll see orders of 75% of costs or 95% of costs and partial orders. They're now starting to come more into mainstream civil litigation, but still are a facet of the commercial courts to a large extent. The most common in the more mainstream claims at the moment is when we get a percentage order, is where there's been multiple heads of claim brought on a case, but the claimant has only been successful on 2 or 3 of them, and they've had to drop 1 or 2 of the others. The court will only make an order in respect of the successful heads of claim and not the entirety of the claim. But again, they're not that normal at the moment, and it tends to be specific cases where there's been a conduct issue as well, quite often comes into that factor, and that's where you'll get your partial order. So thirdly, the other is what offers have been made that aren't a Part 36 offer. Now Part 36 offer, that's a different set of rules, and they are automatic when offers are beaten. But where it's not a Part 36 offer, the offer still has to be considered by the court, but it needs the court to make an order. So if you've made an offer on damages and you proceed to trial and you win, and you beat that offer as a defendant, you can then ask for your costs after the expiry of that offer. But like I said, with Part 36 it would be an automatic position, but when it's not made under the Part 36 regime, then you will have to ask the court to make that order, and that's the provision that they make it under. So having a look at what orders the court will make, we then look at the basis on which the courts are going to assess costs. There's 2 bases for assessment, and that's found at CPR 44.3. You've got the standard basis and the indemnity basis. The standard basis is, as you can imagine, it's the normal basis. If the order doesn't say what basis of costs are to be assessed on, it will be on the standard basis. The indemnity basis is normally utilised as a sanction where a party's conduct hasn't been good, or if offers have been beaten. If you're the receiving party and you're feeling the paying party's conduct has been awful, then you can ask the court to make an order on the indemnity basis. Ultimately, as a receiving party, you've got an order, your normal order would be the defendant pay all your costs. If their conduct's been really bad throughout or on a specific issue, you can ask for indemnity costs on the whole claim or part of the claim there, and that's where the indemnity basis tends to come in.